Welcome to Anatomy of a Lawsuit, where we take you behind the courtroom doors to understand the cases that shape our laws and our lives. I'm Christin Vasquez, Counsel at Dhillon Law Group. Before joining the firm, I had the privilege of serving with the Texas Attorney General's office, where I worked on two groundbreaking lawsuits against Google and Meta that challenged how the biggest tech companies in the world handle your private data.
Google will pay Texas $1.4 billion to settle a lawsuit accusing the tech giant of collecting user data.
Together, those cases comprise of two of the largest privacy settlements in U.S. history, totaling nearly $2.8 billion to Texas. But more importantly, they've redefined the boundaries of how tech giants can handle your personal data. Let's start with Google. For years, Google assured users they could turn off location tracking and activate incognito mode in their account settings to prevent their location and browsing activities from being tracked. But according to the Texas lawsuit, that wasn't entirely true. Even when users disabled location history and browsed the internet under incognito mode, Google continued to collect and store location and search data through other settings like web and app activity. That's like telling someone their security camera's off while still recording them through a different lens. This behavior wasn't just deceptive. It violated Texas's Deceptive Trade Practices Act and similar consumer protection statutes nationwide. After years of litigation and investigation, just this year, Google agreed to pay $1.375 billion to settle with Texas. Now, here's what's important legally. Google didn't just write a check and move on. The settlement also imposed strict compliance requirements, mandating clearer disclosures and user consent before collecting geolocation data. So for the first time, a state forced big tech to translate privacy language into plain English and back it up with enforceable transparency. Now, let's turn to Meta. If Google was tracking what you do, Meta was tracking who you are.
Texas attorneys general saying that they have sued the tech giant, alleging its facial recognition technology violates state law. And now they are seeking hundreds of billions of dollars in penalties.
Surveillance. The state's attorney general, Ken Paxton, now suing Facebook for hundreds of billions of dollars. He's accusing the social media giant of violating users' privacy by harvesting information from photos and videos using facial recognition technology.
Texas sued Meta for using facial recognition technology to collect and store biometric data of millions of Texans without their consent.
The reputation is really so negative around Facebook. I think that nobody necessarily thinks of Facebook and says, oh, that's a company that, I trust with my data.
That included facial templates generated from photos and videos uploaded to Facebook. Under Texas law, specifically the Capture or Use of Biometric Identifier Act, or QB, companies must obtain informed consent before capturing biometric identifiers like facial geometry, fingerprints, or voice prints. Meta didn't do that. In fact, it built entire features like automatic photo tagging on data it never had the permission to collect.
Facebook will agree to a $1.4 billion settlement with the state of Texas.
The result? A $1.4 billion settlement, the largest privacy-related settlement ever obtained by a single state. And just like with Google, the case wasn't only about the money. It was also about forcing accountability, making even the most powerful tech companies operate under the same privacy rules as everybody else. When companies or individuals overstep legal boundaries, courts exist to restore that balance. And these settlements show that even in the digital age, the rule of law still has teeth. For consumers, the message is simple. Your data has value, your privacy has power. I'm Christin Vasquez. This has been Anatomy of a Lawsuit.